there? Are you ready? Not here yet. Let me see. You guys want a record for this?
Yes, Your Honor.
Your Honor, if I may speak briefly before we get started, the parties have been in settlement talks, and we recently sent over.
Oh,
She disappeared.
yep.
Okay, she disappeared. Now you're muted.
I'm so sorry. It had a button up there and it told me to push something, and I pushed it and logged myself off. I apologize. Your Honor, we have been in settlement discussions, and we recently sent over a proposed settlement agreement. I think plaintiffs are asking that maybe we potentially push this hearing out 30 days and see if the parties can come to some sort of agreement. If the opposing party would be in agreement with that.
Sitting here, I can't think of any reason not to do that. I would want to check the timeline real quick and make sure that works for the court's plenary power not running. But I would be okay with that. If I might check my rules book here real quick, Your Honor.
Go ahead.
Okay.
Your Honor, you're muted.
All right, so we're here also on a scheduling conference on the Haylett versus Inception sports case. And so while he's looking that up, why don't we go ahead and get a trial setting for that case?
Judge, I have to start by saying I'm appearing subject to the special appearances of Alex Glandorf and William Chet Irvin. Maybe you're waiting on an order. We got one over this morning. But we've also picked a trial date. Mr. Cole was out for a month, and then I was out Thursday, Friday with family. If we can have February 21st, I think we can get the rest of this sorted out.
February 21st of 2023. Let me see. February 21st, that is a Tuesday. Does that work for you, Mr. Cole?
Yes, Your Honor.
Okay.
Yeah, and Mr. Cole, I looked at your scheduling order. I think you and I can work it out. This $4,000 case probably doesn't need 75 hours the depot per side, but I think you and I can visit about that.
We do want to go ahead and pick out the mediator on the case. Who would you like to use?
I like Melanie Grimes, Brad Lamberth, Bob Genevine. Any of those?
I don't know this first two people, but what do you think, Mr. Cole?
Billy Shirk has done pretty well handling me. I haven't mediated with the three that Ms. LaFouf has mentioned, Your Honor.
I couldn't hear what you said, Mr. Cole. Who did you mediate with?
Billy Shirk Ucherek. Never heard of
Wow. Okay, I must be out of it. I've never heard of any of these people except for Genevieve.
Well, you want to do Genevieve, Mr. Cole? I looked up your guy, Bill. It just looked like he has PI experience, but this really isn't a PI case.
I'd have to, I mean, I haven't looked at this person, but I mean, again, I'm pretty easy when it comes to.
He's a former judge, Judge Genevieve, here in Dallas.
No objection, Your Honor.
Okay. We will go ahead and set it on February 21st for trial, and then we'll go ahead and appoint Judge Genevieve to be the mediator. And the only thing I request is that you put in this scheduling order that all dispositive motions and motions to strike expert will be heard 30 days before trial.
Okay, thank you, Judge. And then we had pending before you still the special appearances of the two individuals. We sent trial briefs in. And then Mr. Cole pointed out to me this morning that we didn't have our proposed order in for them. There was still an outstanding order that hadn't been signed where you denied the special appearance of the corporation and granted the motion to dismiss and denied the motion to disqualify. So we've done an omnibus order and put that in today. And I think Ms. Pinson was just copied on it.
All right, so let's go through this real quick. I see on January 28th, there was a proposed order.
And I think that's Mr. Cole's order denying the special appearances.
Okay.
And on the 25th, we had submitted the one where you denied the special appearance of the entity and asked for more briefing on the individuals. So we gave you an order that denied the motion to disqualify my firm, granted the motion to dismiss the DTPA claim, denied the special appearance of the entity, and now we've resubmitted an order today that adds in the individuals, but grants their special appearances.
And if I recall correctly, I took under advisement the issue of the two individuals.
Yes, sir.
And you submitted, let me see, did you submit a trial brief on this?
We did. They were in by the 28th, I think was the deadline. Yeah, it was that Friday. So we each had a letter brief. You may know you're on mute, Judge. Oh, there you go.
Go ahead and give me that order that you just said it with the omnibus order. Go ahead and email it to Rhonda and e-file it. Rhonda, go ahead and email it to me and I'll either cross out the grant. I'll look at these last two motions, these last two briefs that were submitted and make a ruling today on that.
Thank you, Judge.
Anything else today?
No, that catches us up, I think, Mr. Cole.
Nothing for me, Your Honor.
Thank you, guys.
Thank you. All right.
Mr. Starnes, what did you figure out?
Your Honor, I think that works for us. I think the court's plenary power runs on May 27th, 2022. So, moving roughly 30 days out, we should be okay.
You want me to go ahead and reset this hearing then?
Let's go ahead and do that, and that'll give us time to discuss what plaintiff sent over.
Rhonda, go ahead and reset this to May 16th. That you want to do at 10 o'clock again?
That's perfect for us.
Does that work for you, Mr. Starnes?
Yes, sir.
All right, go ahead and reset this, Rhonda, to May 16th at 10 o'clock. All right, anything else, guys?
Not now, Your Honor. Thank you.
Thank you.
Thank you.
I think we have a motion to strike in this, the Finney case, or is everyone here on that, or it's still a little early?
Your Honor, plaintiff is here.
Your Honor, defense is here.
Mr. Sayer, what are you here for, Ms. Lee or Mr. Lee?
Your Honor, we're on the same case, on the same side. Ms. Pinson had just emailed me. I appeared at 9 o'clock for a DWAP, and I'd received an email to log back in indicating that our motion didn't have enough specific facts in it.
Okay,
It's cause number DC dash.
give me 1 second. Let me. Okay, let me go back to the dismissal docket. Rhonda, I already gave him 30 days. Why are we bringing him back?
I didn't see that. Okay. Now on the dismissal, not the dismissal, but on the substitution of service, the process server didn't state exactly who he spoke with and things like that of that nature on it. So I didn't know if you want to talk to him about that or not. It would still need a hearing later.
So,
On the affidavit part.
I'll look it up real quick since he's here. No, it's fine. I'll go ahead and grant the subservice on it. You submit an order.
Yes, he did. I'll go ahead and put it in your stack for tomorrow.
Okay. All right, I'll go ahead and grant the subservice. It should be scanned and ready by tomorrow, Mr. Sayer, and you still have 30 days, so you have a good day, okay?
Thank you, Your Honor. Have a good day.
All right. Now this Myung Lee, who is that person with?
He's with my firm, Your Honor.
Oh, he's with you. Okay, so you're both excused. Okay, thank you so
Thank
much.
you, Your Honor.
All right, let's go on the record on cause number. DC 205565. Council, make your appearances.
Noosh Kapoor for the plaintiff.
Adam Gallegos for the defendants.
And you guys can go ahead and unmute so that I can hear you. All right, we're hearing a motion to strike. Why don't we go ahead and proceed?
Yes, Your Honor. We filed 4 separate motions to strike. If it pleases the court, I'd like to start with Mr. Pebler.
Go ahead.
Thank you, Your Honor. Your Honor, we've asked this court to strike Mr. Pebler for a few reasons. The first,
Could you spell that for the court reporter?
yes, Your Honor. P as in Paul, E as in elephant, B as in boy, L as in Larry, E as in elephant, R as in Robert.
Okay.
We've asked the court to strike Mr. Pebler's opinions in this matter for a few reasons. The first being that he doesn't hold the requisite qualifications to opine on the crash data. Mr. Pebler is not an engineer. In fact, he's got no college degree at all. He didn't go out to the scene and take any measurements of anything, yet he admits in his work as a police officer, that's something that he was trained to do, that he regularly did. And he further admits that this measurement data is crucial in coming up with a reliable reconstruction. Mr. Pebler's entire report is purely speculative in that his opinions are based upon one assumption, and that's that the plaintiff's vehicle moved forward only 10 feet after this rear end collision. He picks that number out of thin air based on the sole fact that the plaintiff's vehicle did not hit the vehicle in front of her after this collision. There's no support for it. There's nothing that he can concretely say that 10 feet is the right number. He's admitted in his deposition it could be more than that. It could be less than that. He doesn't know. So, Your Honor, based on that, we believe that the report itself is speculation and doesn't assist the trier of fact in understanding any fact that would be before the jury. Further, in their response, the defendants say, well, this data, the skid marks weren't available, the accident reconstructionist wasn't able to go out to the scene. And that's precisely the point, Your Honor. This data isn't available. It wasn't available to the reconstructionist, so his report isn't reliable. If he doesn't have this data, it's not going to help the jury understand anything because it's all based on a guess, it's all based on assumptions, and it's not reliable. So because that data doesn't exist, that's the very reason the plaintiff didn't go get an accident reconstructionist, because it wouldn't help any matter in this case at all.
Is that it?
That's it on Mr. Pebler, Your Honor.
Okay, response?
Thank you, Your Honor. A couple of things that I want to point out to the court that are going to be recurring themes amongst all four of the motions, and that is the qualifications of these experts and Mr. Kapoor's assertion that these experts are not qualified. As we all know, Robinson and Rule 702 state that an expert can be qualified by knowledge, skill, experience, training, or education. And there is a wide body of case law that states that college degrees are not a prerequisite to becoming an expert in a certain field if that expertise comes from one of these other sources. It's also important for the court to note that Mr. Kapoor does not have any retained experts or rebuttal experts designated in the field, especially of accident reconstruction and biomechanics.
So this accident reconstructionist doesn't have a college degree?
He does not, Your Honor. Mr. Pebler, who is a former police officer, has been an accident reconstructionist since 1976. He has reconstructed thousands of accidents. He was the head of accident reconstruction for the Arizona Department of Public Safety for many, many years.
Can you share screen his report?
Certainly. If you'll bear with me one moment, sir. And Your Honor, we did deliver a courtesy copy and paper of this to your chambers. I don't know if you've had a chance to see it. I don't know if that's large enough. I can make the page
Let
the
me
whole
see. I don't think when did you deliver it?
on Friday, sir.
Okay. No, I had a stack of stuff, but that was not one of them. So let me take a look at it.
Okay. I can make this bigger if it helps, sir. This is his report.
Okay.
Mr. Pebler is a certified accident reconstructionist through multiple organizations that he is a member of.
Can you go down?
Certainly.
Go down. Go down. Go down. Go down. Go down. Go down. Okay, stop. Go down. Go down. Go down. Go down. Go down. So he's just making an opinion as to the speed of the impact, but not as to any type of biomechanical that she was injured or not. Let's see.
That's absolutely correct, sir. That's what Dr. Hannon, who will be Mr. Kapoor's next target, is here to do. If I may, sir, he reconstructed this accident based upon the available data. That included pictures of the vehicles, that included the testimony of the two witnesses. There is some level of assumption available in this report that is not denied. However, there is also a wide body of case law that states that an expert is free to use reasonable assumptions in developing opinions, so long as those assumptions have not been controverted by any specific facts in the record. Ms. Fennessy testified that she was at a dead in the water stop in stop and go traffic. She was struck from behind and pushed forward, but did not strike the vehicle in front of her. Being very generous, he gave her the benefit of the doubt and decided that at best she went forward 10 feet. 10 feet is longer than a car length. The vast majority of people do not stop a full 10 car length behind the car in front of them. And Ms. Fennessy also testified that she doesn't follow closely. What Mr. Pebler testified to, and this is this idea of the 10 feet being totally arbitrary. The question that he was asked was, so it could have been 11 feet? He said, it could have been 11 feet, sure. Could have been 12 feet? He said, I don't know. Not based on what was testified to. He couldn't say it could have been 12 feet. What he did determine, though, is that if you start getting into longer distances, 20 feet, then she almost assuredly has to hit the vehicle in front of her, again, because of her testimony that it was in stop and go traffic. The ultimate take from this, Your Honor, is that Mr. Kapoor is free to argue these conclusions to a jury, but this does not make this expert witness or his testimony unreliable or inadmissible.
So here, let's go back up on this. Go back up. So essentially, this guy is a retired police officer, it sounds like, who has, he's not a biomechanical expert. He's not a, let's see.
He is not a biomechanical expert, sir. He does not hold himself out as one. He's well-trained in accident reconstruction and the vehicle dynamics of collisions by virtue of having done it for over 40 years.
Judge, Mr. Pebler is more often than not retained by defendants in these types of cases. The fact remains that the plaintiff's testimony was that I keep a lot of space between the cars in front of me and my vehicle. Mr. Pebler testified that he does not know whether it could have been 12 feet. He doesn't know if it could have been more. And that's the precise reason why the court in this matter should exclude Mr. Pebler's testimony, because it has no reliable facts upon which his testimony is based to assist the trier of fact.
And he didn't have skid marks, right?
Didn't have skid marks. The only thing he had, Your Honor, were some pictures and the plaintiff's testimony. Those are the two things that he relies on.
Does he have pictures of the vehicle or the skid marks?
He has pictures of both vehicles, Your Honor.
But not skid marks?
No, Your Honor.
Okay.
He also had, Your Honor, copies of damage reports to both vehicles, and it should be noted both vehicles drove away from this accident. He is able to use vehicle geometries as part of his work, and he did testify to this to come to an educated guess as to the approximate closing speed. Obviously, and we're not saying he's absolutely sacrosanct on this point, Your Honor, but it is an admissible opinion. It is not cherry-picked out of thin air. It is based on all the available information and utilizing sound accident reconstruction techniques. This is the opinion he chooses to offer. And as I mentioned, Mr. Kapoor can argue this to the jury, which I welcome him to do, but it doesn't render it inadmissible.
Judge, the court and its role as the gatekeeper is to keep irrelevant data and unreliable data outside of the trier of fact's ears, outside of the courtroom. And it's our opinion that this 10-mile-per-hour number that's just been picked out of thin air isn't supported by the facts. It's a guess at best. Mr. Pebler isn't qualified to opine on what could or what would not have been a reasonable amount of space for Ms. Fennessy in the vehicle in front of her. He doesn't know.
But again, that's not what he's saying.
All right, so let me go through this. So I agree, without skid marks or something out there, how you can determine this. So the first opinion as to is his only opinion just how fast she's going, or is there other opinions?
Your Honor,
What? Give me a second to answer my question, Mr. Galejos. Is there only opinion the speed that the defendant was going, or is there other opinions you want me to evaluate?
The opinion that the prime opinion, Your Honor, is that the closing speed, the delta V, which I'm sure Your Honor's familiar with.
I am.
Yes, the delta
I'm
V.
board. I'm just so you know, I'm board certified in personal injury. I did this my whole career, and I've been a
Yes,
judge
sir.
for 16 years, so I'm
And
familiar with this. So
I understand. He says, based on the available data, it is his opinion that the approximate closing speed delta V was 8.14 miles an hour. That's ultimately his opinion.
that opinion is struck. Does he have any other opinions?
He does, Your Honor. If I may offer them to the court, I have them in front of me. Maybe Mr. Gallegos doesn't.
Okay.
The first opinion, Your Honor, as he's been designated in the defendant's RFDs, are that first, the closing speed of defendant Batista was approximately 12 miles per hour.
That one is struck. What's the next one?
The second one is the resulting delta V was 5.71 miles per hour for defendant Batista and 8.14 miles per hour for plaintiff Finney.
That one struck.
The next is the principal direction of force acting on both vehicles produced no rotation of either vehicle.
No rotation. Okay, I'm not sure I'm familiar with that. No rotation of either. What does that mean? Like the wheels didn't rotate, or does it mean that the vehicle didn't rotate?
Judge,
May I address that?
Yeah, go ahead. I'm just not familiar with that.
What he's saying with that, principal direction of force is the direction upon which the closing vehicle, that is the defendant's vehicle, was coming, and it's determined by which part of the vehicle, of plaintiff's vehicle he struck. So the principal direction of force was coming essentially from left to right because the defendant struck with the left driver's side corner of his vehicle, struck the plaintiff's rear passenger side corner, as the pictures demonstrate, but did not hit it hard enough to cause that vehicle to spin. That's what the rotation is referring to here. That also goes into how he's able to determine how much the closing speed would have been. A faster closing speed at that principal direction of force, simply one corner to one corner like this, would have caused her Mustang to spin had it been faster than that. That's that's where all of this is going. That's
so
what
Your Honor, if I
principal
may
direction of force
add,
is.
that is solely based again on speed. He's coming up with that no rotation based on the speed, the closing speed of the vehicles. So again, he's assuming the speed and then likewise backing into this logic to assume that the plaintiff's vehicle did not rotate as a result of the collision.
She didn't testify to rotation. She said she got pushed forward, not rotated. There was no evidence of rotation. That's all of this goes into the whole closing speed argument, which I know Your Honor's already said is struck, although I would ask you to reconsider that in light of this principal direction of force. This is not just cherry picking.
The problem I have is I can see the argument about rotation, that it would take a certain speed, that you could calculate a certain speed and figure out what the speed would need to be in order to cause a vehicle to rotate, but it wouldn't be a precise speed. It would be under a certain speed. Let's say, I have no idea based on, it would depend on the lining up of the vehicles, but I can see how that could be calculated. But I don't see how you could do a precise speed. I'm going to hold off on ruling on that one. I may let that one in, just on the rotation, that it didn't cause it to rotate. So what's the next one?
The next one, Your Honor, is the crash pulse was in a worst case scenario, 150 milliseconds.
Okay, argue that one.
Your Honor, in his deposition in the deposition of Mr. Pebler, he's readily admitted that 150 milliseconds could easily not be the crash pulse.
That's not exactly what he said.
Judge, I'm summarizing, Your Honor. I can pull up the exact wording in his deposition, but that was what I believe and what I recall the gist of it to be.
May I, Your Honor?
Go ahead.
The crash pulse, of course, being a measure of the amount of the time of contact between the two vehicles. There's ample literature cited in his report that says that in a rear end collision, this is typically 100 milliseconds or 1/10 of a second. It is his opinion that it could be as long as 150 milliseconds or 1500ths of a second. And he bases that on the fact that the defendant's van sits much higher than the plaintiff's Mustang, which sits very low to the ground. And there was clearly some override of his bumper on her bumper. That causes a greater amount of time of engagement, which again, based on principles and his experience, might be as high as 150 milliseconds. That's where he's coming from. That's the basis for it. It's a sound scientific basis, and it's based in the literature.
Your Honor, if I may quickly respond.
Okay.
Mr. Pebler is not an engineer. He doesn't hold a college degree, doesn't have any type of formal training in engineering, yet he's opining upon principles that are solely founded in engineering and physics, things that he is not qualified to opine about. But if we put that aside and we continue to discuss his opinions based on that fact.
So a police officer, reconstructionist, can calculate speeds with skid marks and other data. I'm not sure how they would do it with this particular data. Like, he doesn't have any, what does he rely on, I guess, to come up with this 150 milliseconds opinion?
If I may, Your Honor, his entire logic for the crash pulse is derived from the delta V. The delta V is the very first input that Mr. Pebler calculates based on the 10-foot assumption.
Okay, that one struck then. That makes sense. Next one.
The next opinion, Your Honor, is the resultant impact would have pushed plaintiff forward a maximum of 10 feet.
Yeah.
This has likewise been proved untrue by his very own deposition testimony, where he has testified that it very well could have been.
And there's no skid marks. No one's looked at skid marks, so that's struck.
And the final opinion, Your Honor, is that the plaintiff most likely did not strike her head on the steering wheel because as she testified,
struck.
And that concludes his opinions, Your Honor.
All right, everything is struck except for the rotational opinion as to this expert. So let's go to the next one.
Okay. The next one, Your Honor, is Dr. Hannon, and he is the biomechanical engineer that's been designated by the defendants in this matter.
Okay.
Likewise, we argue that Dr. Hannon is not qualified to opine on the biomechanics and precisely the causation in this matter because he's unqualified. In his deposition,
does he have a college degree or no?
He does have a college degree, Your Honor, in physical education and exercise. So
he's not a biomechanical expert. He doesn't have a.
Oh, he most certainly is, sir.
If I may continue, Your Honor, he, in his deposition testimony, his intimate knowledge of biomechanics is grounded in 6 neuroscience classes, 2 biomechanics classes, and in his words, some independent studies that he completed as a part of his coursework. That is the extent of his biomechanical education, Your Honor.
Okay.
Okay, may I?
You may.
All right. He obtained his doctorate in education in 1980, and in that time has spent the last 42 years in the field of biomechanics. He is, in fact, a professor emeritus, distinguished professor at Northern Arizona University in forensic biomechanics. This is his textbook, sir, which is one of the leading textbooks in forensic biomechanics in the United States. The man has spent his entire career studying, developing, publishing, and educating in the field of biomechanics. He is not a medical doctor, and he's not being held out as a medical doctor. He is, however, abundantly qualified, as few people in the United States are, to opine on the biomechanical aspects of a crash. It is what he does. He does it, and before Mr. Kapoor says so, he does this almost equivalently on the plaintiff and defense side. He does it in criminal and civil cases. He's been doing it for decades. He's never been struck because of his lack of qualifications, and to single out his college degree from 1980 is a bit disingenuous.
And Your Honor, if I may quickly respond to that. So first, I'd like to respond in that if we put the qualifications to the side, Dr. Hannon, by his own testimony, has admitted that step 1 in his analysis is based solely on Mr. Pebler's data. That was step one in his determining how the body is going to move as a result of this collision. He takes all the crash data from Mr. Pebler and then extracts his opinions from it. So based on there being a lack of reliable foundation and the fact that Mr. Pebler's opinions have now been struck, we would urge the court to also strike Dr. Hannon. Furthermore, the defense has argued that he has not been designated as a medical doctor and he doesn't hold himself out to be a medical doctor. But in fact, in his deposition, he has likened himself to an expert on spinal injury. He's even said that he is going to opine on medical causation in this matter when he's not a medical doctor.
He is opining, Your Honor. I'm sorry. Go ahead, Anuj. Sorry.
I'm just going to conclude that those two things are nonsensical. They don't line up to me, Your Honor. If you're not a medical doctor, I'm not sure how you are qualified based on your physical education training to opine then on medical causation.
Let's go through his opinions, I guess.
Yes,
What are his
Your Honor.
opinions?
Are you going to share Anuj or you want me to?
I'm pulling it up right now. I'm happy to share my screen or I can read them off if you'd like.
Just read
Your
them
Honor,
off.
before he does that, I'm just, for the record, now that you've struck most of Mr. Pebler's opinions, I have a hunch that that's probably going to follow that a lot of Dr. Hannon's opinions are going to have to be struck too, although I disagree obviously with that. The point being is that the first aspect here was his qualifications. And again, to single out a college degree from 42 years ago Rule 702 is clear. That's not the be all end all of his qualifications. He is a highly skilled biomechanist and biomechanics.
Let's get to his opinions
Okay.
and figure that out.
Your Honor, the first opinion is any cervical and or lumbar spine ligament strain, facet joint pathology, or intervertebral disc pathology present in plaintiff Finney is not the result of this accident, nor was it aggravated by this accident, by this event.
That's struck.
The second one is that the collision at best would create mild delayed onset muscle soreness.
Struck.
The third is that there is no scientific basis for a mild concussion as a result of this accident.
Struck.
And the final and fourth opinion is the plaintiff suffers from degenerative disc disease that is not a result of this accident.
Struck.
Those conclude his opinions, Your Honor.
All right, what's our next expert?
The next expert I'd like to address is Dr. McMaster, Your Honor.
Okay. And I will tell you, that was the only one that I actually saw on the docket. So I've actually read this one. For some reason, we have a new clerk. Maybe I'm just putting stuff on there that in a different way, but go ahead and make your argument as the McMaster.
So I'll very briefly go over it, Your Honor. Dr. McMaster has been designated to opine on the reasonableness of the plaintiff's medical charges and the necessity of treatment. We do not argue his qualifications as to the necessity of the treatment. We're solely striking or asking the court to strike Dr. McMaster for his opinions on reasonableness of medical charges. Very briefly, Your Honor, if you look through his 18001 and his support for it, Dr. McMaster solely looks to Medicare, Medicaid, and pre-negotiated insurance reimbursement rates. The court, as has been held in Haygood v. Escobedo, these reimbursement rates see dollars much lower than cash basis payers. And that's just a fact that the courts have evolved over time. That's a known fact.
How do you, I totally agree with you. I think it's apples and oranges, but with In re Allstate, how do you, I know that that's not a motion to strike an expert, but how do you reconcile that? Because clearly that's what the expert did in that case, was they compared it to Medicare, Medicaid, and other forms of doing this.
So my response to that, Your Honor, and that's why we didn't pose this as an 18001 motion to strike. I believe In re Allstate deals solely with the counter affidavits and the affidavits themselves. And that's a purely procedural process. The plaintiff files their notice and they serve an 18001. In that event, it saves the plaintiff from having to designate a doctor and bring them live at trial to talk about the necessity of treatment and the reasonableness of charges. If the defendant now has any counter affidavit, that negates our initial 18-001, and we are thus then forced to bring our doctor live at trial. Purely procedural. I'm arguing this as a motion to exclude based on the Daubert and the Robert.
I get it. I mean, and I agree with you. If the law was according to Judge Hoffman, I would definitely strike, because I think it's totally apples and oranges. What a self-payer versus what someone has with Medicare and Medicaid is totally different. But and I know there's a recent opinion out of the Dallas Court of Appeals on this issue. Are you familiar with what I'm talking about?
I have not briefed that one, Your Honor. I apologize. I'd be happy.
It may just go to 18.01. It may go to the counter affidavit solely, but it ruled in favor of the plaintiff, and it was after In re Allstate. Mr. Glass, do you know the opinion I'm talking about?
Out of the Dallas Court of Appeals, sir, I do not. I'm obviously familiar with In re Allstate, but I've not seen that recent opinion.
So he looks at Medicare, Medicaid. What else does he look at?
CPT codes based on pre-negotiated reimbursement rates, Your Honor.
May I respond?
Yeah, you can.
Again, it's an opinion. It's an opinion based on sound methodology. Mr. Kapoor would have you believe that, or have the court believe that, and this is true, that any medical provider can charge literally anything they want at any time. That doesn't mean it's a reasonable reimbursement rate. Dr. McMaster takes a number of things, the CPT codes, pre-negotiated insurance plan rates, Medicare, Medicaid, and comes up with, based on his experience and his knowledge of what is a reasonable reimbursement rate, offers a different opinion. If he's not allowed to, I'll put it to you this way. One way or another, I think this is going to have to get in front of the jury for two reasons. One, either we're going to agree that Mr. Kapoor can put his affidavits in, but only if I can put my counter affidavits in which case Dr. McMaster's opinion comes in, or he has to bring his doctor live or somebody to testify as to those charges being reasonable and necessary, and then I'll be allowed to put Dr. McMaster up to rebut that reasonable and necessary charge. So I think this motion has to be denied only because it has to come in one way or another. There's no way around that based on In re Allstate and based on.
So let me tell you what my concern is, and that I'm, I see the train coming if it isn't already here. I have a real problem. I don't have any problem with McMaster testifying. Doctors for years have testified about, I've looked at other, they compare apples to apples, other self-payers, this is what's in the market. I've talked to other doctors, blah, blah, blah. And compare that to what's charged. And Dr. McMaster could easily, in my opinion, testify to that and say, I've looked at other people and what they charge for self-payers, and this is way above that. And I have no problem with that. Personally, I have a problem with using Medicare, Medicaid, health insurance reimbursement rates, because I think it's apples and oranges. In re Allstate seems to indicate that's okay, at least in counter affidavits. It didn't go that additional step. I believe there's a case out of the Dallas Court of Appeals that addresses this, but I could be wrong. But I would definitely want that briefed. I'm definitely not going to strike Dr. McMaster's because he can testify about necessity. When is your case set for trial?
May 10th, Your Honor.
And I agree. Are you guys going to, one option would be, have you guys talked about building affidavits, or are you guys going to each call your own doctors live?
I was planning on calling our doctor live at trial. I assume Mr. Gallegos was planning on the same.
I was absolutely planning on bringing Dr. McMaster live to trial, if for no other reason than to talk about the necessity of the treatment. Certainly.
Why don't we do this as to the issue of reasonableness? Why don't we, I'm not going to rule on that right now. Why don't you see if you can find that Dallas Court of Appeals opinion, and this area of law is changing so rapidly. Let's discuss it again on the day of trial and figure out what the state of the law is, but try to find that Dallas Court of Appeals opinion. It cites in re Allstate. I think it was the Judge Justice Peterson wrote the opinion, if I recall. And you can tell me if it may not be exactly on point, but it's pretty close to being on point, if I recall. So, and of course I have to follow the Dallas Court of Appeals. So let's hold off on that. Okay, what's the last one?
Okay, and the last motion to strike is regarding Donna Johnson, Your Honor.
Go ahead.
Donna Johnson has been designated. Well, let me back up, Your Honor. Donna Johnson produced a report in this matter, and she provides opinions based on the earning capacity of the plaintiff and her lost wages, in addition to a critique of the life care plan that the plaintiff has offered in this case. In their designations, the defendants only designated Donna Johnson's opinions regarding the earning capacity of the plaintiff. They did not offer her opinions as to the life care plan itself. Based on that, we objected in our motion, and we asked that the court strike those opinions based on the lack of designation, number one. But if you look towards her qualifications, Your Honor, it's, as Mr. Gallegos said, it's a similar thing here. Donna Johnson is not a life care planner at all. She's not certified. She does not have the qualifications of a life care planner. She has worked as a case manager for a governmental entity for a number of years. And in that work, she says that she has prepared life care plans. She's got no support for it. She's got no work experience that details life care planning except for the words life care plan on her resume. But there's no detail about what it entailed, what was the scope of the life care plan, anything like that, Your Honor. Simply, she gives herself that title based on those three words. And so based on those issues, we ask that the court strike her because she's not, one, qualified as a life care planner to opine on those issues. And two, she wasn't designated as in that form.
Starting with the objection, I'm sorry, may I, sir?
Yeah, go ahead.
Okay, starting with the objection, that's a little bit of a disingenuous argument. Basically, what he's saying is because I didn't put it exactly word for word in the designation, the 194.2 disclosures, precisely that's the reason to strike. Actually, if you take a look at what I put in there, what she's being designated as is for vocational analysis and life care planning. On top of that, Mr. Kapoor had a detailed report that listed all of her opinions. He had ample time to depose her and ask her about all of those opinions. So to now come back and say, because specific words were not put in our 194.2 disclosures, and I dispute whether or not that's actually true, then he objects to these opinions coming in. So I think that's a little bit off topic here. Number two, Donna Johnson, based on her CV and based on her testimony, stated she's been working in life care plans, not only writing them, but detailing them, examining them, determining the efficacy of a life care plan, almost, I think, longer than I've been alive, sir, and I just turned 49 last week. She's been doing it since 1972. Now, does she have a certification as a life care planner? No, but that's even a bit unusual because the certification that Mr. Kapoor complains she does not have comes from an organization called ICHCC, which his own expert, who I have not moved to strike, I think his opinions are way off, but I haven't moved to strike him because he's qualified to do it, happens to be a commissioner of that. So based on his own expert saying that because you don't have a certification from our commission, you're not qualified to do this, again, misstates what 702 says. She's worked in this field for longer than I've been alive. For almost 50 years, she's been working in this field. She has provided detailed analysis as to why not only, and this actually goes to Mr. Provder's report about her, Mr. Provder, his expert is going to testify that Ms. Finnessy has 20% future reduction in earning capacity. All right, she testifies directly to that. She's qualified to do that in terms of not only her experience, but as a vocational counselor, in addition to her life care planning. But she's also opining that
I'm going to deny the motion to strike as to this expert.
Okay.
All right, Mr. Kapoor, if you could do this, I've made a number of rulings today. If you could go ahead and prepare an order as to all of those. At the beginning of the order, if you could say that this was heard on April 4th, 2022, as opposed to on this day. So don't do a blank, just put on April 4th, 2022. I made a number of rulings. I know it's a little complicated, and so make sure you share it with Mr. Galejos. And make sure it delineates each opinion that I've struck or haven't struck. So make sure it goes through that level of delineation. Try to get that to me. I'd like it by tomorrow if possible, but try to get it to me sometime before Thursday for sure. Share it with Mr. Galejos. You'll have 2 hours, work hours to respond to it, and then you can go ahead and submit it. Anything else today, guys?
Just quickly, Your Honor, I want to just make sure, would you like me to prepare separate orders for each of the?
One omnibus order.
Okay, got it.
Anything else, guys?
That's it. Thank you, Your Honor.
Nothing further, sir.
All right, you have a good day.